Hello guys, welcome to another episode of this particular video. By name, I am Japhet Okaka Ebosetale. So today, under constitutional law, we'll be looking at role of judges in the administration of justice, and we'll be answering the question whether or not judges can actually make law. Now, you will remember that Section 4 provided for the legislature with the power and duty of making laws. The legislature was provided for in Section 4 of the Constitution with the duty and role of making laws. However, the judiciary was provided for in Section 6 of the Constitution with the power and duty of interpreting the laws. So there are controversies as to whether judges can actually make law. So in answering this question, two schools of thought were established. In answering the question whether or not judges can actually make law, two schools of thought were established. What are the two schools of thought? Number one, we have the declarative theory. We have the declarative theory. Number two, we have the interpretative theory. So these are the two theories that were established for answering this particular question. Now, the declarative theory is saying that judges do not make law. This particular theory is saying that judges do not make law. This particular theory is saying that it is the duty of judges to interpret the law and not to make the law. That's what this particular theory is saying. This particular theory is saying that if there is a gap, if there is a space in the law, it is not the duty of judges to make law. It is just the duty of judges to interpret the law as it is. It is not the duty of judges to modify or to change or to amend the law. This is what this particular theory is saying. And for this particular purpose, we'll be looking at the case of Okumagbe versus Igbe. Okumagbe, I'll spell it Okumagba versus Igbe. Now, let's look at what the Supreme Court stated in this particular case. Now, look at what the Supreme Court said. The Supreme Court said that feeling that the appellant deserve to be punished, the Chief Magistrate replaced the word another candidate with the words any candidate. Feeling that, this is what the Supreme Court is saying in this particular case, feeling that the appellant deserve to be punished, the Chief Magistrate replaced the word another candidate with the words any candidate, and thus enable him to punish the appellant. In effect, he amended the regulation, but the amendment is the function of the legislature. It is the duty of the legislature to amend the regulation. That is what this particular theory is saying, and not the function of judges. Now let's move further. It further said that, and the court cannot fill a gap. You see it? It is the duty of the legislature to amend the regulation, and also if there is a gap in the law, the courts cannot fill the gap. That is what this particular theory is saying. Now, as Lord Bacon said in his essay on judicature, the office of a judge is just discernment. The office of a judge is just discernment. and not just therein, and not just therein. As Lord Bacon stated in his essay, the office of the judge is just therein, and just therein, and not just therein, which is to state the law and not to give the law. That is what this theory is saying. This theory is saying that it is the duty of judges to state the law and not to give the law. That is what this particular theory is saying, and we have further seen it in the case of Okumagbe versus Igbe. Now moving forward in the interpretative theory, the interpretative theory is saying that judges can modify the law. The declarative theory is saying judges cannot modify the law. However, the interpretative theory is saying that judges can modify the law, and if there is a gap in the law, the judges can actually fill in the gap. Now, Lord Denny is part of the interpretative theory, as he said in the case of Court Seaford Estate versus Asha. This was what Lord Denny stated in the case of Seaford Estate versus Asha, which I'm going to read to you what Lord Denny said in this particular theory. Now, look at what the Lord Denny said. He said, "We do not sit here to pull the language of Parliament to pieces and to make no sense of it." That's what Lord Denny said. He said the judges, they do not sit to make no sense of the language of the Parliament. No. However, that is easy to do, and it is a thing to which lawyers are prone. We sit here to find out the intention of the Parliament and ministers, carry it out, and we do this better by filling in gaps and making sense of the enactment. That is what Lord Denny said. We do it by filling in gap. So this particular theory is saying that judges can actually fill in the gap. Judges can actually modify the gap. That is what this particular theory is saying. This particular theory is saying no, judges cannot make law. Judges cannot fill in the gap. They are just to interpret the law as it is. They are to state the law and not to give the law. That is what this particular theory, which is the declarative theory, is saying. However, the interpretative theory is saying that judges can actually fill in the gap. Judges can actually modify the law. That is what this interpretative theory is saying, which Lord Denny falls under. Now, there's a particular question. The positivist thoughts fall under the declarative theory. Lord Denny fall under the interpretative theory. What theory does Nigeria fall under? What theory does Nigeria fall under? Nigeria falls under what we call the liberal approach. The liberal approach. This is what Nigeria courts fall under. The liberal approach is saying that if the strict interpretation of the law, if the judges interpret the law strictly, if the strict interpretation of the law will lead to absurdity, or will lead to or manifest injustice, if the judges interpret the law strictly, and if they are to interpret the law strictly, it will lead to absurdity or it will lead to injustice. The judges can actually modify the law. They can actually fill in the gap when the strict interpretation of the law will lead to absurdity. That is what the liberal approach is talking about. If judges interpret this particular law strictly, it will lead to absurdity, it will lead to injustice. The courts, the judges can then modify the law when it will only lead to injustice. That is why in the case of Central London Property Limited versus High Train Limited. In the case of Central London Property Limited versus High Train Limited, which brought about the doctrine of promissory estoppel. Now, what is the doctrine of promissory estoppel say? The doctrine of promissory estoppel is saying that if S borrows money from Y, S borrows money from Y, borrows 10,000 naira from Y, for example, and he tells Y, borrow me 10,000 naira. In March, I'm going to pay you. And Y gave S the 10,000 naira. And it goes to the month of March. And Y requested the money from S. S, give me my 10,000 naira. Oh. But S now is telling Y that, it's only 4,000 naira I have. I don't have the 10,000 naira again. And Y later tells S, okay, just give me 8,000 naira. If you can give me 8,000 naira, I will not ask of the full 10,000 naira again. Just give me only 8,000 naira. And S that is with only 4,000 naira hurriedly do one or two, sell some of his property, got that extra 4,000 naira and add this to the 4,000 naira that is with him, which is now 8,000, and gave the 8,000 naira to Y instead of the 10,000 naira. And Y accepts the 8,000 naira. And subsequently, Y is telling S, oh yeah, give me back my 2,000 naira balance. It's 10,000 naira you borrowed, and you paid back 8,000 naira. Give me back my 2,000 naira. And S is like, you told me if I can bring 8,000 naira, you accept it. If Y sues S to court and S rely on the doctrine of promissory estoppel, Y cannot recover that money back. It will be seen that Y is estopped, Y is stopped from recovering that 2,000 naira. That is what the doctrine of promissory estoppel is talking about, which is also under the liberal approach, at which they are to interpret it strictly. S, give him back the money. Give him back the money. That kind of interpretation can lead to injustice. That is why the liberal approach, this liberal approach, is say that if the strict interpretation of the law will lead to injustice, will lead to absurdity, the judges, the courts can modify the law. And is this liberal approach Nigeria courts fall under? So this is what we have for the role of judges in the administration of justice. Thank you so much for watching, and God bless you. By name, I am Japhet Okaka Ebosetali. Thank you.